I said that I was going to give you specific ideas about how to approach this specific issue, the marriage amendment. So I'm going to give you 5 ideas for how to approach it in a way that will be productive. And the first one is this. It's something I've touched on before, and that is be brave enough to talk to people that disagree with you or who haven't decided yet. Don't just discuss this amongst ourselves. Now, how do you find those people? Well, I suspect you already know them. They're at work. They're at your church in some instances. And there are places that you intersect with them all the time. They're the other parents on the soccer team that your kid plays on. And does this issue come up? Yeah, it does, if you raise it. And that's a scary thing. It is the scariest thing. And believe me, you know, going to Regent University and talking about the death penalty is scary too. But it's not scary in the same way as it is talking to someone one-to-one who you know very well. And I do understand that. But if there's going to be social change, it has to be through changing the minds of people who are against you or who haven't decided yet. And the first step towards doing that is engaging in dialogue with them. And that's a step that too often isn't taken. So that's the first thing, is find a way to engage in dialogue with people where it might make a difference. The second thing is this. Anger is valuable, but not as advocacy. I'm never going to tell people, especially people who have had experiences that I haven't had. I am a relatively affluent, straight, white, male, native-born citizen. That means there's a lot of experiences I haven't had that make people angry, and in which that anger is justified. So don't hear what I'm saying as, don't be mad about that. Be mad about that. But don't confuse anger with something that's going to change someone's mind. Too often we lead with anger. And that has its place. But it's not usually going to be effective advocacy in terms of changing someone's mind. One of the things I've been working on for a couple years is juvenile life without parole. I'm against the sentence where someone who's committed usually a murder, often a heinous murder, as a juvenile, then gets the sentence of life in prison with no possibility of parole. I think that's an unjust sentence because juveniles are different, that they change over time. One of my opponents, or two of my opponents on this, are sisters in Illinois, the Bishop sisters. And the Bishop sisters, Jennifer and Jean, the third sister in that family, Nancy, was murdered by a 16-year-old. And it was a terrible murder. This guy broke into the sister's house, shot the husband through the back of the head. With the gun, approached their sister Nancy, who said, "Don't shoot me, I'm pregnant," which she was. And he lowered the gun and shot her through the belly. And she died on the floor. And so for them, they want the sentence of juvenile life without parole. In fact, the way that I met them is I was testifying in Congress in front of the House Judiciary Committee, and I was for a bill that would get rid of juvenile life without parole. The primary witness on the other side was Jennifer Bishop Jenkins, one of the two remaining sisters. And she was passionate and bold and articulate, and in many senses right, even though I disagree with her on the ultimate issue. So anyways, I joined with the Bishop sisters and said, what do we agree on? What can we agree on? And what we agreed on is this, is that it's wrong to transfer juveniles mandatorily to adult status where there's a mandatory sentence of life without parole, which is true in several states, including my home state of Michigan. And so we went back to the Department of Justice. We got a meeting with the Department of Justice and some other groups to try to talk them into changing their policy regarding that. And we got a meeting, they were receptive, and then we had a second meeting. And at the second meeting, one of the other people who was with us was from a nonprofit advocacy organization. And we started talking about the issue and what the problem was. And out of the blue, this woman said, "The problem is you," pointing at the lead negotiator for the DOJ. She said, "The problem is the decisions you guys are making because you don't care about kids." And that killed it. It was over. You could see them stiffen up, get defensive, and we didn't get another meeting. Despite the fact that we'd gone to all that work to find common ground and try to promote it, that anger and blaming negated all the advocacy we'd done to that point. So the first thing is talk to those who disagree. Don't make anger be what you start with. The third thing is this: start from common interests or beliefs, not from differences. That I don't want to start with someone by saying, "We disagree about this." Now, where do you start? Well, if you're starting with someone, let's say someone who is Catholic, who is taking the word of the archdiocese and saying, "We must be for this bill." What do you have in common with that person if you're a member of this church? Well, you're both people of faith, and that's a starting place. Maybe they're saying, "Well, we need to defend the family." Well, they care about families, and most people do, and you can accept that as a starting point. This is a difficult thing to do when you're talking to people who have angered you or are opposed to you on something really important. But here's a couple ways to think about it when you're doing that. Number one is I often think physically about a circle, that I'm drawing a circle around us both, and thinking about what defines that. And that's what I'm going to talk about first. Yes, there's differences, and we're going to get to that, but I want to start with that. The other thing, and this is something that I do physically when I'm in trial, is that I want to walk to where they are and then turn the same direction they are. As a prosecutor, if I'm giving my closing, I can argue to you like this. But let's say I've got a piece of evidence. It's a gun that's up on the stand. It's much more effective for me to walk over close to where you are, turn around, and we're all looking at the same thing. We're all facing the same direction. So think about that metaphorically, that what you have to do is walk to where they are, turn around, and walk with them back to where you want to go. I think that's very powerful as a way of thinking about things, because it requires you first to go to where they are. But remember, the destination is where you end up, not where you start out. And that can be pretty crucial. The fourth thing is affirm their interests, is that when you identify that common ground, I care about families, it's about my faith, affirm that. Very rarely is someone going to say, "It's because I'm a bigot." So you're not going to be affirming something terrible. Usually you're going to be affirming something good. And that's a good idea. And then use that. Use their interest in a positive way. Finally, you want to end the conversation with respect. That there's something called the recency effect that some of you may have read about, that people tend to remember the last thing that they did with someone, and that's how it colors it. There's a terrible, terrible study that was done about colonoscopies where they found that people's satisfaction with their colonoscopy entirely depended on the last 3 minutes of the experience. And so they trained doctors to lie about it and just say, okay, we're still working, when actually they were done. And satisfaction with colonoscopy skyrocketed. So if you're in a conversation with someone about this and it's not going well, change the subject to something else. Come back to it another day. For 2 reasons. People change their mind over a long period of time. No one reads a bumper sticker and says, "Oh, I will vote for Romney." That's not how we work. Stories, conversations, connections to people change our mind over time. The other thing is you never know who else is listening. There's something happening at St. Thomas tomorrow that I'm really looking forward to. There's a guy coming to speak named Andrew Densimo. And he's a defense attorney. He's a public defender in Detroit. In 1997, when I was a true believer in the sentencing guidelines, I had a lot of crack cases. And one of the crack cases was against Andrew. It was a guy named Anthony Bull Shepard. He was 18 years old. He was caught with 5.3 grams of crack, which isn't very much, and a gun hidden under a couch cushion. And that meant that he had a mandatory minimum sentence of 10 years with no chance of parole in the federal system. Now, I didn't really prepare for sentencing. It was a mandatory sentence. So I showed up in front of the judge and said, Your Honor, it's 10-year sentence. I didn't even take the file over, probably. And the judge turned to my opposing counsel and said, Mr. Densimo, are you going to make your usual futile argument? And he said, yes, I am. And he went on for 20, 25 minutes. And he talked about the racial effects of the federal law that punished 1 gram of crack the same as 100 grams of powder. He talked about how it didn't work, how there was still an awful lot of crack out there in Detroit, despite the fact that we'd been pursuing this that way for a long time. He talked about that individual kid who was 18 years old and what else he might be doing for those 10 years that would be better for everyone. And when he was done at the end of his 20 or 25 minutes, the judge turned back to me and said, Mr. Osler, and I said, Your Honor, it's a 10-year sentence. And she gave him 10 years. And I went back to my office, and there were some people sitting around, and they said, what have you been doing? I said, oh, I had a crack case. And they said, oh, do you have Densimo? And I said, yeah. They said, do you give the futile speech? And I said, yeah. And we all kind of laughed about it. But you know what? That worked on me. Because over time, I couldn't stop thinking about it. And I knew he was right. Everybody around me in my office thought he was wrong and thought it was funny. But I knew he was right. And I left. And I went down to Texas and I started to work on crack issues. If you've ever heard of the movie American Violet, that's about one of the cases that I did involving crack in Texas. And then taking on the federal guidelines, I worked with the ACLU and we started to bring cases, and we lost. I lost in 5 courts of appeal. I was America's least successful appellate lawyer. I lost personally in the 8th and 9th circuits on consecutive days, which is difficult because the 9th circuit's in California and this is the 8th circuit. So I had to, fly and have a student come meet me and brief me and lose horribly. But then we won in the Supreme Court. And you know who wrote our opinion? Justice Scalia. That's pretty good. And so what Justice Scalia said in his opinion, it's United States versus Spears, was that judges could categorically reject the 100-to-1 ratio. I love that word, categorically. And the next day after this came down, it came down the day after President Obama was inaugurated, January 21st. And I got all these calls from district court judges because it mattered a lot to them because the decision was saying you can come up with a different ratio if you want to. And this judge from Detroit named Art Tarnow called me. And he said, Osler, what happened to you? I saw your case. And I told him the story about Andrew Densimo. And he said, did you ever tell Andrew that? And I hadn't. So I called him up. And that's who's coming to St. Thomas tomorrow. 12:30, if you want to come. Room 235. But that's what happens sometimes. You talk to someone and they seem like a jerk. Wait a little while. Sometimes it takes some time for it to sink in. Too many times I have been that jerk, so I know.